How quickly do you think this matter will be resolved?
Well, all indications are that the D.C. Circuit intends to rule on this matter promptly. They set a very ambitious briefing and oral argument schedule as soon as the matter was presented to them. So the briefing was very expeditious, and the oral argument is going to be on Tuesday. Judge Chutkin, the district court, wrote a very thorough and well-reasoned opinion below. They have very good briefing before them in the court now. So I imagine that it will not take them very long to decide how they're going to come out. Perhaps it may take some time for them to write an opinion that all judges will agree to sign on to if they are hopefully going to have unanimity. But I expect that they will make up their minds fairly quickly and that we might have a ruling within the week after they hear oral argument.
Do you think the process will be as expedient in regard to the 14th Amendment case that former President Trump has now formally asked the Supreme Court to take up, overturn the Colorado ruling that found him disqualified from seeking the presidency once again because of the insurrection they say took place and he engaged in on January 6th? Is there any world in which the Supreme Court, A, doesn't take that up and B, can't figure that matter out before the Colorado primary in March?
So I think that I cannot imagine a scenario in which the U.S. Supreme Court does not take up the issue of whether or not the former president is disqualified from being on the ballot under Section 3 of the 14th Amendment. That said, the timeline under which the Supreme Court would take up the case and then decide the case is much harder to predict. As of now, we don't know if they're going to take it. There have been petitions for certiorari filed now by the former president and by the Colorado Republican Party. I don't think the court really needs to wait to hear the opposition from the voters who brought the action to try to knock Trump off the ballot in order to decide whether to take the case. Usually the court would wait to see the responding filings from the party who didn't seek the certiorari. But in this case, I don't think they really need to wait to see what's going to be in those briefs because those voters also want the issue decided. It's in their interest also to know whether or not the former president is disqualified. So I think the court already has before it what it needs to decide whether or not to take up the case. The question is just going to be how quickly will they make that decision? And then if they do take the case, and I expect that they will, what kind of briefing schedule will they set? There is precedent, including in the Bush v. Gore case of 2000, for them to act very quickly. So I think they can act. The question is quickly. The question is, will they?
Well, the question also is what decision ultimately do they come to, whatever timeline that may be. If they don't actually make a ruling based on this question of insurrection, answer the question as to whether or not Trump engaged in it and therefore whether or not he's ineligible, if they find another way potentially to overturn Colorado, would that ruling then be applicable to these other cases in Maine and elsewhere across the United States that have raised this issue similarly? Does what they decide in Colorado apply to all?
It depends how they rule. If they rule that the presidency is not an office of the United States within the meaning of Section 3 of the 14th Amendment, then that would mean that no state could hold the former president ineligible for office because he was not an office holder within the purview of the section of the 14th Amendment. So that would resolve this issue for all states. Similarly, if the Supreme Court were to hold that the Section 3 of the 14th Amendment is not self-executing, that it requires authorizing legislation from Congress that provides a mechanism or authorizes the states to decide under state procedures whether or not a candidate is authorized to run for office under Section 3. That similarly would be a holding that would be applicable to all of the states. So there are a number of ways in which the court could decide the matter that would have national applicability without reaching the question of, number one, what does it mean to engage in insurrection as a legal matter? And then the factual question of whether or not the former president engaged in insurrection.
If they do, though, wade into those insurrection waters and trying to answer those questions, would that have any bearing on the case here in Washington that Jack Smith has brought, understanding that he didn't actually charge Trump with insurrection directly, but all of those charges he did bring surround his events leading up to and on the day of January 6th? Could an insurrection decision from the Supreme Court have any impact on that case?
So that's a really interesting question. And you note accurately that the former president was not charged with the crime of insurrection in the January 6th criminal case. If, for example, the court were to go ahead and reach this question of whether or not the former president, his conduct amounted to insurrection or whether it was protected by the First Amendment, that latter question of whether it was protected speech effectively is something that I think would have repercussions for the criminal case. Because in the criminal case, similarly, the former president is going to be arguing that he engaged simply in protected political speech. So if the court were to hold that, in fact, his conduct was protected by the First Amendment, I don't see how that would not have significant ramifications for the criminal case, not only in D.C., brought by Jack Smith, but also potentially in the Georgia state case that's been brought by Fani Willis.
Well, in regard to Jack Smith, we also had an accusation from Trump today that Smith was violating a stay order with some of his activity around this case and essentially wants him held in contempt. Is that just a legal tactic or could that actually have consequence?
I don't see that action going anywhere. I mean, what Jack Smith has been doing is essentially continuing to do his work. His prosecutors have been filing their motions in limine. They've been providing discovery. They're doing basically everything they can do to keep the case on track, but noting each time that they have no expectation that the former president is going to respond because of the stay. So I don't see the motion for contempt going anywhere. That said, it actually points to another really interesting aspect of the upcoming argument in the D.C. Circuit next week, which is whether or not essentially the stay needs to remain in effect pending appeal. One of the most significant aspects of this immunity claim has been that it is subject to an interlocutory appeal, and that while the immunity question is resolved by the appellate courts, the district court entered the stay so that the case could not go forward, and the trial couldn't go forward essentially on March 4th unless there's a resolution of the immunity question before then. There's been this very interesting friend of the court brief filed recently that the D.C. Circuit will consider in the argument next week about whether or not, in fact, a stay is required in these circumstances, and also whether an interlocutory appeal is appropriate in the context of this criminal case. Those issues weren't really briefed by the parties. It's this friend of the court brief that raised it anew, but the D.C. Circuit issued an order telling the parties to be prepared to address this and other questions raised by friend of the court briefs. So I'm going to be very interested to listen to the argument on Tuesday to see where the court goes with this particular question, because if the court decides that a stay is not necessary, that might allow the proceedings to continue, not only for the special counsel to continue filing the motions, et cetera, that you were just talking about, but also potentially essentially relieving the pressure on the schedule and contemplating that the trial could go forward on March 4th, even if the immunity question is not fully resolved by the appellate courts by then.